Mr. Malik.
Good morning. If it please the court, I appear with my learned friend Mr. Adam Temple. The respondents are represented by Charles Graham, King's Counsel, Michael Darcy and K.V. Krishna Prasad. Before I give the court a roadmap, can I just start off by making a general observation? We contend that, as your lordships have seen, that there is a profoundly unsatisfactory situation that we are in at the moment. The context is important. This case concerns substantial litigation before Mr. Justice Andrew Baker, which is now drawing to a close after over 4 years of intensive case management. These proceedings originally involving 106 defendants and claims valued at 1.44 billion has been a significant undertaking. The trial commenced in April and is now in its final stages with closing submissions imminent. The case, as I understand it, is going to involve closing submissions, oral submissions, going over 2 months, and so there would have been 4 terms. My client's position in this matter is unique. Initially a party to those proceedings, my client was removed following Mr. Justice Andrew Baker's determination of a preliminary issue. His lordship held that all claims against all defendants were inadmissible under the revenue rule. Although the Court of Appeal, this court, and the Supreme Court later determined that the revenue rule did not apply, permitting the main proceedings to continue, SKAT deliberately chose not to challenge Mr. Justice Andrew Baker's specific finding of inadmissibility against my client. This has created what we submit is an anomalous and troubling position. The judgment on inadmissibility remains in force against my client alone, solely because SKAT elected not to appeal it. The question before this court is whether SKAT can now circumvent that subsisting judgment by pleading a fresh claim in deceit. The judge below, Mr. Justice Bright, concluded that Mr. Justice Andrew Baker's revenue rule decision was confined to the specific claims then pleaded against my client, thereby permitting SKAT to pursue new proceedings against my client outside the main litigation. We respectfully submit that this decision is erroneous on 2 grounds. First, the judge misapplied the principles of issue estoppel, which required him to look beyond the precise claims pleaded to the fundamental basis of Mr. Justice Andrew Baker's revenue rule determination. Secondly, allowing SKAT to advance this new claim constitutes a Henderson abuse of process. This appeal therefore raises issues of significant practical importance. The notion that SKAT can initiate parallel proceedings, contrary to Mr. Justice Andrew Baker's subsisting judgment on inadmissibility, we submit undermines the principles of finality in litigation and the efficient administration of justice. Now, against that brief introduction, can I just briefly outline the structure of my oral argument, which falls into 6 parts. First, I will give an overview of the trading activity underlying both the original claim and the current claim. Second, I will outline the position prior to the revenue rule trial heard by Mr. Justice Andrew Baker in March 2021. This will include a brief examination of SKAT's intimation of a fraud claim to provide context for the later arguments. Third, I will review Mr. Justice Andrew Baker's decision, identifying its essential steps and addressing how it was considered on appeal. Fourth, I will examine the case law on issue estoppel to demonstrate that it encompasses not only the ultimate conclusion of a judgment, but also the essential steps underpinning the decision. Fifth, I will address Mr. Justice Bright's reasoning and SKAT's arguments on the issue estoppel point, explaining why their interpretation of the issue determined by Mr. Justice Andrew Baker was too narrow. And then finally, I will move to ground 2, which is a freestanding ground focusing on abuse of process. So if we can start off with a very high level examination of what the case is about, could the court please turn to S2, tab 44, page 561. And perhaps also, I don't know whether you've got it in a separate document, but in the core at tab 13, there's a schedule 2 to the pleading of SCAT, which helpfully sets out a glossary of terms which we will come across from time to time, and it might be useful to have that to hand when we look at this document. So the first point is it's headed ED&F man, my client. It's a tax voucher, and in this document, my client confirmed that its client, and you can see that the client referred to at the top, it's DW Construction Inc. retirement plan, was holding a stated security over what is called the dividend date, and that's referred to in the schedule there that the court has. There are various other dates listed: the ex-date, the record date, the pay date, which are explained in due course, and a reference at the bottom there to that first part, to WHT, that's withholding tax suffered in the sum of DKK, that's Danish kroner, 1.96 million, and the rate is specified as 27%. So as the currency indicates, this tax voucher relates to Danish shares. The reference to WHT is to the Danish withholding tax, which was deducted at source in the sum of 27% from the relevant dividend payments. This immediate claim and the original claim concerned payments made by SKAT, in other words, the Danish tax authorities, which they say relied upon misstatements in tax vouchers like this. And to be clear, these vouchers were not submitted by my client ED&F. They were submitted by reclaim agents on behalf of ED&F man's clients, but they were produced by ED&FM. And I wanted to start with this document because it's the heart of SKAT's claim, and the references to underlying trading patterns and fraud or negligent misstatement that these tax vouchers are central, and they are central both to the original claim and to the new claim. In the original claim, ED&F man was concerned with 420 of these tax vouchers, and on the basis of those 420 tax vouchers, SKAT claimed that it had paid out some 574 million Danish kroner. This was something like 5% of the overall claim value against all the defendants. In bringing the current claim, the new claim, SKAT rely on 281 of these tax vouchers, the same tax vouchers, but they've added in 5 additional tax vouchers that were omitted from the first claim for some reason or another. And the claim value has dropped from 574 million to 339 million Danish kroner.
What's that equivalent of, roughly?
I think you divide by 10, isn't it?
Sorry, the original was 70 million.
It's 70 million, now 56 million. I think. I'll come to and so that means that SKAT has dropped something like 140 tax vouchers from the claim altogether. So there's a difference there. Now, the deletions, the reduction in the number of tax vouchers doesn't matter for the present purposes of the appeal. But what this does show that SKAT apparently now accepts that something like 40% of its claim value in the original claim was not fraudulent. And I make this point because SKAT paint my client as having concocted a fraudulent system for tax refund payments, but they seem to accept that at the very least there were elements of the withholding tax refund system which were operated in good faith by my clients. But returning to the piece of paper in front of us, Save for the 5 additional tax vouchers I mentioned a moment ago, the current claim relies on the same tax vouchers from the original claim. The alleged misrepresentations are also pretty much the same in both the original claim and the current claim, which is hardly surprising given that the information on the pieces of paper has not changed. And you would have seen from our skeleton argument the 2 sets of representations, and the reference there is at C, page 44. Now, also in both the original claim and the current claim, SKAT say that they relied on the tax vouchers to make payments out reliance on the alleged misrepresentations. That alleged representation is obviously the same in both claims, and again, that is what one would expect. Whatever the new allegations that SKAT put forward about the underlying trading or the mental state of ED&F's employees, that cannot have had any impact on what SKAT did with those pieces of paper after they were received by SKAT.
When you said alleged misrepresentations, one of the representations pleaded is that the dividends were paid to the particular client. Am I right in thinking that your client accepted in the original claim that that was a false representation in at least some of the cases?
That's great. And see, we'll come to that in a moment. And I'll explain the pleadings in more detail.
But in some of them, do you say there were no misrepresentations at all?
Well, we accept there were representations, but we don't accept that they were false.
Yes.
And I'll come back to the differences between the 2 claims in due course. And the differences relate to the underlying trades in the shares and the allegation that the ED&FM acted fraudulently rather than, as in the original claim, negligently. So that is a view from the highest viewpoint, if you like. I'm going to now descend one level to describe the kind of share trading with which these claims are concerned. Now, there's a difference in terminology. We've referred, I think, to the language of dividend arbitrage trading. SKAT refers to this as cum-ex trading, but even the phrase cum-ex trading, I think, is disputed. But the terminology aside, in essence, what we're talking about is the trading of shares in Denmark around the dividend date. Depending on precisely when the trade happened, the purchaser either bought shares cum dividend, that is, buying the shares with a right to receive the dividend attached to those shares, or ex-dividend, buying the shares without any right to the dividend. And just for completeness, when we speak of Danish shares, we're speaking of shares held in dematerialized and fungible form at the time by an entity called VP Securities, the Danish Central Securities Depository. That entity was acquired by Euroclear in 2020 and subsequently renamed to Euroclear Denmark. But it was VP Securities at the time. Now, in order to understand what we're talking about, could the court turn, please, to the supplemental bundle tab 42 at page 529. And this is an extract from the report of Mr. Graham Wade, and you can see this at 526. And it's referred to in the judgment of Mr. Justice Bright in December 2021. And the reason I'm looking at it now is just because it's convenient in terms of an explanation of the key dates around dividends in Denmark, as we saw from that tax voucher a moment ago. And 529 is figure 1, headed illustrative settlement timeline starting off on Thursday, the 5th of December, to Wednesday, the 11th of December. And just below the dates on the left-hand side, you can see that these are described as Kollepast dates, and Kollepast is the name of a Danish company. Now, the first date is 5th December. it's not implicit in this timeline, but if you look at the previous page, paragraph 104, you will see there that Colopass dividend was confirmed at Colopass AGM on 5th December 2013. And if we go back to figure 1 and go along that upper line, we can see that 6th December is described as the ex-dividend date, and that is the date on which anyone buying shares in the market is buying shares without the right to dividends, and this is the ex-dividend date, as you can see from the abbreviations in Schedule 2 in the call that I referred to a moment ago. So Colopass confirmed their dividend on the 5th of December, and so a trader had the rest of the 5th of December to buy the shares cum dividend, that is with the right to the dividend, and 10th of December, going along that line, is the record date, and that is the date the shareholders on the share register would be paid the dividend, and that's again referred to in the Schedule 2 abbreviation, the record date. And then the dividend would be paid on the 11th of December, and that's the payment date on this diagram. It's the same, I think, as the schedule which talks about payday, payment date. It's the same. So there are two features that I should highlight. One is the time that trades take to settle. The other is the impact of double taxation treaties on share transfers. Now, share transactions do not settle instantaneously. The contract is agreed one day, but the money and the shares do not change hands until later. And at the time of this graphic, the default was that settlement would take 3 days. If you see a phrase like T+3 in any of the documents, that's a reference to settlement 3 days after the trade. But of course, parties are free to agree to different settlement dates if they choose. In particular, they can agree to settle on a later date. And that takes me then to the second green and yellow line on the diagram, which shows the trades making up the dividend arbitrage trading. So you see on the 5th of December is listed the buy date, and this is the date that ED&F's client bought shares in Colopass. Because it is before the ex-dividend date, the client is buying them cum dividend. And you can see at the bottom right-hand corner the statement buy date +4. This means that this trade was agreed to settle 4 working days after the transaction. That's the 11th of December. 6th of December is listed as the sell date. That's the date that the same ED&F client sold the shares in Colopass. This transaction takes place on the ex-dividend date, so the client is selling the shares ex-dividend. And at the bottom right, you will see sell date +3, meaning that this trade would settle 3 working days after 6th December. In other words, this trade would also settle on 11th December. And the point of these trades is that the client wants to get the dividend because he has a tax advantage. And I'll come back to the details of the tax advantage in a moment. But there is a complication because the client is not registered as a shareholder on the 10th of December, the record date. And this means that the Danish company would have paid the dividend to the original seller of the shares instead of the purchaser of the cum dividend shares. And in those circumstances, the market practice was that the recipient of the dividend would pay it across the party who had bought the cum dividend shares. In fact, even if the seller did not have the right to a dividend for some reason, the seller would still pay across a sum equivalent to the dividend to the purchase of the shares, because the purchaser bought the shares cum dividend and has a right to that payment. Now the tax complications come in because in Denmark, the Danish company would have withheld 27% of the dividends. That is the 27% that we saw on the tax voucher a little while ago. And this is known as withholding tax and is deducted at source. This means that the dividend paid out by the company is 73% of the dividend, announced dividend. It is this figure that in fact gets paid across by the seller of a cum dividend share, not the full 100%. However, double taxation treaties exist between Denmark and other countries, including the USA and Canada. And these treaties state that the pension plans are not liable for the withholding tax So in this example, if ED&F man's client was an American pension plan, and if it had suffered withholding tax, then it is entitled to apply to SKAT to refund the 27% that has been deducted at source. And the big question in these trades is whether the buyer received a dividend traceable to the company. And these are points of detail which may complicate matters if the claim proceeds. But in broad terms, there were two possibilities. The most straightforward situation is that the buyer who sold the share on the 5th of December was the full legal and beneficial owner of it. They received a dividend from the company and they passed it to the purchaser. In that case, there would have been a withholding tax paid on the dividend. But another alternative was that the seller did not hold the share on the 5th of December, and this would arise if the seller was a naked short seller who was intending to buy shares after the trade date to fulfill the trade on the settlement date. In this case, the naked short seller would still make what's called a 73% dividend compensation payment, but they had not received the dividend from the company. In essence, and in non-technical sense, the payment is not traceable to a dividend paid out by the company, so it cannot be said that the withholding tax has been deducted from the dividend payment. So that's the kind of, we'll come back to this later, but that, broadly speaking, is an overview of the trading structure. There are complications, but this is in essence an outline of what the voucher is, and a very brief introduction to the arbitrage trading, or the cum-ex trading, as is referred to by SKAT.
Can I ask you a question? I understand that if the seller on the 5th of December is a naked short seller, they're not the shareholder on the record date, so they don't actually receive a dividend at all, but they still pay what you call the compensation payment, which is calculated at 73% of what the dividend would have been.
Correct.
But you said that if the seller on the 5th of December transaction did hold shares, then they would be on the record date, so they would receive a dividend.
Yes.
And they pay it over, or its equivalent.
That's my understanding. Yes.
Yes. Now, is it your case that means that the recipient, that's man's client, did receive a dividend?
In that example, yes.
But they weren't on the record, so they didn't receive a dividend from the company.
Yeah, I think that's right. Yes.
What they receive is they receive payment of the same money or an equivalent sum from their seller, but they're not on the record, so they're not receiving a dividend from the company. Is that right? Have I misunderstood what the point is?
Yeah, Mr. Temple's saying that we believe that there's no objection to that.
There's no objection to
that type of transaction.
Okay.
But I think we're going to come back to some of these in a moment when we look at the detail. So can I start off by looking at the lead up to which I think is my third topic or second topic, which is looking at the position in the lead up to the revenue trial. With that background in place, I turn to the original claim in the lead up to the revenue rule judgment handed down on the 27th of April 2021, which we rely upon as giving rise to the issue estoppel. And I start with ED&F's amended defence dated the 5th of September, which is in the supplemental bundle at tab 9 at page 131. So that's the page 1 is the front of the document. Just for completeness, you'll see the revenue rule point was taken at paragraph 56, but at page 135. But 137 is what's called is Annex E, and this is where the phraseology comes from, the incorrect tax vouchers. And paragraph 2 acknowledges, I should have said, is that until these amendments, ED&F had denied any inaccuracies in the tax vouchers. But as you can see from the first paragraph here, ED&F identified 80 tax vouchers which contained inaccuracies. Paragraph 2 acknowledges that the PP, the pension plan, that the reference in the pension plan client, that's the pension plan client of ED&F man, had not received the amount set out in the relevant tax voucher by way of dividend and had not suffered withholding tax in the amount set out or at any date. Paragraph 3 sets out ED&F's position that it was SKAT's own negligence which was the real and substantial cause of the payments. And over the page there is a list of tax vouchers setting out the extent to which ED&F accepted that SKAT had overpaid withholding tax refunds to ED&F's man. Adding it all up comes to the equivalent of 183.9 million kroner, or about 32% of the total claim against ED&F man in the original claim.
Sorry, can I just get the figure? It was
183.9 million Danish kroner, which we calculate as being 32% of the total amount claimed against ED&F in the original claim. That figure of 183.9, for your lordship's note, is from SKAT's skeleton argument at paragraph 12. And the 32% comes from dividing this sum by the total amount claimed, which is the 574 million that I referred to earlier. And these tax vouchers remain in the current claim, but because of the reduction in tax vouchers that SKAT relies on overall, this represents slightly more than half of the claimed overpayments now pursued by SKAT. And you would have seen in our skeleton arguments reference to Annex E tax vouchers, and this is the genesis of the distinction between Annex E and non-Annex E vouchers. Now, after we served this amended defence, SKAT asked a number of questions about Annex E, and we can see this from ED&F's Part 18 response, dated the 26th of September, which is in the supplemental first bundle at tab 11 at page 175, and this is on the headed paper of Rosenblatt, those instructing me, and we don't have the actual requests in the bundle, but you can see from the fourth paragraph of this page that the request related to, and it quoted the circumstances in which the Annex E tax vouchers were produced. So that's where it comes from. And then over the page, in paragraph 2, you will see the response that SKAT is not entitled to the information it requested, but that without prejudice to that position, what is said is this: is in relation to the shares described in the inaccurate parts of the Annex E vouchers, we confirm that on or after the settlement of its purchase of shares in the Danish listed company, the pension plan received a payment which was equivalent in value to a dividend of 27%, but which was not a dividend net of WHT, which had been paid by the Danish listed company. And as I mentioned earlier about payments made on a cum dividend shares which were not derived from the dividends paid by the Danish company, this letter was confirming that the pension plan clients received such payments which were not traced to a dividend paid out by the Danish company. So after we admitted this in September 2019, SKAT amended its claim against ED&F man pursuant to an order dated the 31st of January 2020, and which you can see in SKAT's re-amended particulars of claim, which are in this bundle, supplemental bundle 1, at tab 10, page 164. So that's where that January date comes from at the top there. And if we can start, please, at paragraph 3, we can see that the sorry, if we can turn to 164. which is a specific formulation of a claim against my client. So re-amended Schedule 5T is directed against ED&F, which, as you can see at the top there, is the 69th defendant in the first claim. And if we can start with paragraph 3, the allegation is that ED&F devised and structured a scheme to enable it to profit from the making of apparently eligible withholding tax applications. And if we can move ahead to paragraph 10, at the bottom there, page 166, it is suggested that each of the tax vouchers produced by ED&F contain 4 representations, which your lordships can read there. And then at paragraph 11, there are a number of implied representations. And you can see that even though this claim was framed in negligence at this stage, the representation in 11C was that each tax voucher was an honest and accurate statement of the facts set out in it. And then from paragraph 15, moving on to page 168, the claim in negligent misrepresentation was set out. And of particular importance is at page 170, paragraph 18, in which the allegations of falsity appear. Subparagraph A repeated back to us our own admissions about the Annex E tax vouchers, namely that the client had not received the amount set out by way of dividend and had not suffered the tax claimed. And then the subsequent subparagraphs B to D expand on this theme. And then subparagraph E over the page is dealing with what we call the non-Annex C tax vouchers, alleging that the clients did not hold and were not the beneficial owners of the relevant shares and had not received any dividend as beneficial owner. And as you can see from subparagraph 1, little one below that, underneath that SCAT alleged that to the extent that the shares were purchased, the clients held them for the benefit of ED&F. And you can see how we responded to this in our re-amended defence, and that's dated as 12th of June 2020, and that's in the same bundle at tab 12.
Before you move on, one of the representations pleaded at page 167 was that the specified number of shares were held by the PP on the reference date. Which of the various dates on the timeline does the reference date refer to?
Let me come back, if I may, on that.
Yes, thank you.
My learned friend knows this backwards. In fact, he's moonlighting by being here today. Delightful to see him.
The reference date is the dividend declaration date, or the first of the dates in that spectrum.
Thursday, December the 5th, I think.
So in Mr. Wade's example, it would be Thursday, December the 5th.
That's when the AGM is held, which confirms the declaration of the dividend.
So when the dividend is declared, that is the moment when the entitlement arises, although it's not one's not recorded as being entitled to it until one's on the record by the record date. But the reference date is a reference to the day on which the dividend is declared, the date when the first of the trades that are referred to by Mr. Wade take place.
Thank you.
I thank my learned friend. And then we can see how we responded to this at page 205 of this bundle. At paragraph 19.1 there at the bottom, we admitted again that the Annex E tax vouchers were inaccurate. And in the final 3 lines, we stated that a review had revealed that the relevant pension plans had received a payment which was equivalent in value to a dividend net of 27% WHT.
Sorry, you're going a bit too fast for me. Where are we?
Sorry,
206.
Page 2, so 205, S205, paragraph 19 of the pleading.
Thank you.
Sorry, my lord, and it's 19.1 at the bottom there. That's the admission that we make, and the point about the being equivalent in value to a dividend of 27, but not the identified net dividend itself. And then over the page at paragraph 19.3, we maintain that its position that the rest of the tax vouchers, which are the non-annexee tax vouchers, were accurate. And it was and remains our position that each pension plan purchased shares from a third-party market participants and ED&F believe that each PP had received dividends net of WHT. Now, there are more versions of SKAT's particulars of claim produced before the revenue rule, but those are irrelevant to the claim against ED&F, and there are further pleadings that were going to what's called the validity issues. But in material terms, that's how the statements of case looked at the time of the revenue rule trial. Now, if I can turn to the genesis of the revenue trial, turning for this purpose to the bundle J, which is where the judgments are, and at tab 1, which is a judgment of the Mr. Justice Andrew Baker.
I'm sorry to keep asking you questions. Can I ask you another question? The claim, the original claim, is for damages for negligence, is it? Negligent misrepresentation.
Correct, with other unjust enrichment as well, claims as well, yes.
But the unjust enrichment is not about the dividend payments, it's about the fees that you got from running the scheme, isn't it?
I think that's right, yes.
So the bulk of the claim is
negligent misstatement.
Negligent misstatement and damages. Are those Danish law claims or English law claims? Or
They're both are pleaded.
both are pleaded?
So I'm not sure where it ended up in the trial, but at the stage then it was both Danish and English law.
Thank you.
Now the judgment is July 2020, which I think would have been fully virtual, and so we're just into COVID by a few months, and you will see from page 2 from page 3 the cost of thousands, and at paragraph 2 he went to refer to this as, we say correctly, mammoth litigation, and you would have noted Mr. Justice Bright's reference in his judgment to Mr. Andrew Baker's vigorous commitment to active case management of the litigation, and so effectively he has case managed this case from the beginning, and is now the end going towards the end of the trial, and this reflects a reality that SKAT's original claim was and is one of the most complicated pieces of commercial court litigation. So there's been a designated commercial court judge throughout, and the sums are large, the parties are numerous. And this is important to bear in mind as we look at issue estoppel and an abusive process, because SKAT's approach to ED&FM has led to us being carved out of the court's management of this litigation. No doubt it will be said that this is not to our detriment, which is something I will come to, but from the perspective of court resources, this new litigation is an additional burden on top of this initial mammoth litigation. Paragraph 5 of the judgment, Mr. Justice Andrew Smith sets out the 7 stages of analysis that he saw the claims as going through, and from paragraph 7 he sets out the revenue rule issue, and in the light of SKAT's focus on the revenue rule issue as defined in the subsequent audits, notable how he refers to it here, and you can see that, and then at paragraph 7 he refers to the case management list of issues, which are any of SKAT's claims barred by the revenue rule, and if so, which claims and why? Now, framed in this way, the issue is not only just whether they were barred, but also why they were barred. And in paragraph 9, he suggests that it is a significant and it may be an important point concerning the nature and scope of that rule of law and how it applies to the causes of action alleged by SKAT. But that is in the nature of the issue, that is to say, an argument of law. and acknowledged that the range of different causes of action and issues as pleaded meant that it would not be a 1 or 2 day argument, but suggested it could be addressed with 2 days of pre-reading and 4 days of argument. And these paragraphs do not suggest a tightly defined issue tied to details of the underlying allegations. Instead, they are concerned with the proper scope and application of the revenue rule to SKAT's claims as a whole, which Mr. Justice Andrew Baker saw as an issue primarily of law. And the order that came out of this judgment is in the supplemental bundle 1 at tab 16, if the court could turn to that please, at page 248.
We should keep the judgments file to hand.
Yes, we're going to come back to it.
Yep.
Yes, please. So this is the tab 16, tab 248, the order that was made at the CMC, and over the page at paragraph 2, you can see the reference there to the revenue rule being listed for 6 days by reference to issue 1 of Annex B of the order, which is there at page 254. And note also paragraph 3, which then sets out detailed directions. Effectively, a number of parties had come forward to effectively argue these points, and they are listed. Effectively, there are these lead defendants that are appearing at A and B, and then other defendants shall, and this is at C, have filed their revenue rule submissions on the 16th of October. And then paragraph 5, the outcome of the revenue rule shall be binding on all parties, irrespective of whether or not a party filed revenue rule submissions or a skeleton argument or participated in the revenue rule trial. The corollary also being that the party shall be entitled to permission to appeal and to exercise any appeal rights irrespective of prior participation at the revenue rule trial. And then, and I'll come back if I'm, and then if I could go to 254, you'll see the issue 1 being the revenue rule, and the question being whether any of SKAT's claims, as alleged, inadmissible under Dicey Rule 3. And again, the issue is framed not only are the claims inadmissible, but why they are inadmissible, and I'll come back to that issue. Now, just before we look at what happened at the trial, I have one further detour to look at the intimations of fraud that ED&F received in the lead up to the revenue rule trial. This is by way of scene setting, but is also relevant to our abusive process case, to which I'll return to later in my submissions. The first document to look at is in the supplementary bundle number 2 at tab 4025. And this is a letter from Vincent Masons, who are acting for SKAT in this matter. It's dated the 18th of December 2020. And the second paragraph suggests that this is, quote, a final opportunity.
I'm sorry, it's my fault. I haven't got the document. Could you give me the reference again?
It's supplementary bundle 2, tab 25, page 328.
Thank you.
So paragraph 2 said the purpose of this letter is to provide you with a final opportunity to provide us with the full and frank explanation of the Annex E tax vouchers, which explanation we have sought since September 2019. And over the page, in the third paragraph down, Vincent Mason stated that they were driven to conclude that if there were an innocent explanation, it would have been provided. And from the penultimate paragraph, it stated that in the absence of a satisfactory response, we shall infer that the Annex E tax vouchers are evidence of dishonest conduct on the part of one or more of your client's employees, namely that they were produced to enable WHT refund applications to be made that those employees knew to be invalid or did not believe to be valid. We shall also write to you in the new year concerning irregularities and anomalies in the non-Annex E transactions that gives us cause for concern. So this letter is a clear intimation of fraud, and the response from my solicitors is in tab 26, and as you can see, it's dated the 11th of January. And if we look at the numbered paragraphs about halfway down, it explained to SCAT that the payments were made by ED&F Man Proprietary Trading Dubai Limited, and pointed out that this was identified in spreadsheets that SCAT had by now received in disclosure from EDFM. So here we are a couple of months before the Revenue Rule trial, telling SCAT that this entity, which we've been calling EDFM Dubai, was the party making the payments. In this letter, it was referred to as MPT Dubai, but it's the same entity. Then paragraph 2 continues, having acquired the right to the relevant Danish shares on a trade date, or the question was why the payments were made, having acquired the right to the relevant Danish shares on the trade date prior to the reference date, the pension plans had a contractual right to dividends in respect of such shares. However, the counterparty MPT Dubai was unable to pay the pension plan's dividends in satisfaction of such rights because it did not have a right to the relevant Danish shares on the trade date and thus did not receive the dividends from the underlying Danish company. Accordingly, MPT Dubai satisfied its contractual obligations to the purchasing pension plans by paying sums equivalent in value to those dividends, net of 27%. So this was EDFM telling SCAT expressly that the Dubai entity was a short seller in relation to the Annex E tax vouchers. The Dubai entity did not have the shares that they were selling to the clients. And you recall from my description of the trading that this is a possibility. And this was a reason why EDFM accepted that the Annex E tax vouchers were inaccurate. And I should emphasize that this is only concerned with Annex E. So in my respect for the submission, it's therefore clear from this letter what was taking place. And if we can then turn to paragraph 3 of this letter at page 330, the same point is being made, where it is stated that the employee of EDFM did not understand at the time that the payments received by the pension plans could not constitute dividends net of WHT, i.e. although equivalent in value, they were not dividends which they'd been paid by the underlying Danish company. So while EDFM denied fraudulent intent, this text also made it clear that the dividends had not come from the Danish company and that WHT had not been paid. Now, there was a further letter from Pinsent Masons, which is at 334 of this bundle. So that's supplementary bundle tab 28, page 334. And this is dated the 15th of January. So shortly, only 4 days after the previous letter. SCAT had previously said that we had one last chance to explain our position, and paragraph 2 of the letter says, you have not satisfied us that Annex E tax vouchers are the result of an honest mistake. And then it continues, it appears that all such trades were conducted on the basis that they would not involve the acquisition of shares in or the receipt of dividends from the relevant Danish companies. Nevertheless, such trades were presented to Mr. Mead on the false basis that the pension plans were the owners of shares and had received dividends in that capacity. Again, we submit that that's an allegation of fraud. It says that EDFM knew that there were no shares, and SCAT asks, do you accept that this ignorance was a result of deliberate concealment by individuals within NPT Dubai? Again, tantamount to an allegation of fraud. And then over the page, then there are pages of detailed questions. And there is then a page 4, which unfortunately is not in the bundle. But if I could, with the court's leave, hand up the missing doc page. And the only point I wanted to make is there are a whole series of questions, and the last paragraph on page 4, we will await your response by no later than close of business on the 22nd of January by way of a reminder, as stated in our letter. In the absence of satisfactory responses, we shall infer that Annex E tax vouchers are evidence of dishonest conduct on the part of one or more of your clients' employees. And so based on its references to fraud in the correspondence, it certainly appeared that SCAT was preparing to advance a claim of fraud. SCAT was obviously gearing up for the revenue rule trial, but its questions, its actions at the time raised a number of questions. But it's important to note that SCAT did not apply for permission to amend its pleadings or indicate to Mr. Justice Andrew Baker that it was considering such an application. Instead, it was content to let the revenue rule trial proceed with the implicit threats of amendments lingering in the background. And we would say this, is that if SCAT believed that the distinction between its claim of negligent misstatement and a claim of deceit was relevant to the revenue rules application, its decision to mention potential amendments only 3 weeks before the trial demonstrates a notably casual approach. And this suggests that SCAT expected to pursue those amendments after the revenue trial if it succeeded in that trial. And this approach indicates, we submit, that SCAT understood that the revenue rule trial would not and could not depend on the specific causes of actions alleged against ED&F. Accordingly, it signalled a potential fraud claim without formally amending its pleadings. And this reflects the overall nature of the revenue rule trial. And this is important and critical to the argument on issue estoppel. All the parties proceeded on the assumption that the outcome would be binary. Either all the claims would be deemed inadmissible or all the claims would be admissible. There was no suggestion that the trial's outcome would depend or vary between defendants or as between causes of action. And we'll see that that is how Mr. Justice Andrew Baker saw matters. He refers specifically to private causes of action, but his understanding of the revenue rule is that it makes no difference whether it was a claim of deceit, whether it was a claim in negligence. It was all about characterization and the substance of the claim being brought by the Danish authority. The individual causes of action made no difference at all to the analysis, and that, in our submission, is important. Now, ED&F
at later stages, certainly in the Supreme Court, and I think also in this court, it was said as one of the arguments put forward by SCAT that fraud made all the difference. But is it the case they didn't run that argument before Mr. Justice Andrew Baker?
No, I can't see it. We're looking at it, but that argument was not run. It was not suggested that there was any difference. And that's what Mr. Justice Andrew Baker actually found as well. The first time that there was a hint that there may be a difference about the Annex E was in an application that SCAT made to Mr. Justice Andrew Baker after the revenue trial for permission to appeal, but that didn't go to the Court of Appeal, that argument. So there was, and I'll take your lordships to that.
Thank you.
Now, ED&F man's substantive reply on the Annex E tax vouchers was on the 5th of March 2021, and you'll see that in supplementary bundle 2 at page 31. tab 31, page 341. So this is the response that was requested, I think, in January. And the third paragraph here explained that the Dubai entity had been part of ED&F group of companies until March 2016, had now been sold, and ED&F had no contact with the trader at the Dubai entity. And just below that, there's a heading MPT Dubai. And this letter explained that the Dubai entity had been an associate entity of ED&FM, and that ED&FM provided back office and support services to MPT Dubai. Then page 2 of this letter, in the second paragraph, it is stated, it is correct that MPT Dubai entered into trades in respect of shares which it had no rights to. As no shares or rights to shares were held by MPT Dubai at the trade date, ED&F man accepts, as clearly pleaded in the re-amended defence, that the Annex E tax vouchers were inaccurate and no WHT was payable. The pension plans nevertheless contracted to acquire dividends because they entered into trades on trade dates which were prior to the relevant X dates. So this is another clear statement that the Dubai entity was a naked short seller when it sold shares to ED&F man. And as I've said, SCAT did not apply to amend its claim, and the revenue trial started 17 days later on the 22nd of March 2021. Now, the key points that we say emerge from this correspondence are as follows. First, SCAT had indicated potential fraud and applied that it would formally allege fraud if it did not receive satisfactory answers. Second, SCAT accused ED&F man of deflection, refusal to engage, and presenting a misleading defence. This was more than a request for clarification. It was a firm assertion of alleged wrongdoing. Third, SCAT posed a series of detailed questions spanning multiple pages. In response, it received a short reply which failed to provide direct answers. SCAT can't credibly claim that this response that we just looked at alleviated its suspicions. And finally, the correspondence made it unequivocally clear that the Dubai entity was a naked short seller. Consequently, the payments to ED&F man's client did not originate from the Danish company, and no withholding tax had been incurred in connection with those dividend payments.
I understand what a short seller is. What does naked mean in this context? It means it has no shares at all.
No shares at all, yes.
As opposed to somebody who has some shares but not as many as it sold, is that right?
Well, nor that he borrowed them either. I didn't have them at all, but sorry, I'm sad to be corrected, yes.
I mean, I think the difference in this context, a short seller is someone who sells without having the shares. A naked short seller is someone who sells shares without having any arrangements by which he can get hold of the shares by the settlement date. And therefore what one's looking at here is whatever the position may have been on the trade date, on the reference date, on the dividend declaration date, what is being said about a party's ability to get hold of shares in the interim, so that one can be a short seller and still settle one's trade on the settlement date if one buys the shares in during the course of the trade.
Or borrows them.
Or borrow them, absolutely, my lord. But if you're a naked short seller, then you've got no arrangements in place to enable you to do that. You may, of course, still be able to do it, but you've got no arrangements in place to enable you to do it.
Thank you.
So before turning to the revenue rule trial itself, I just want to show you one final document, which is in the supplementary bundle at tab 33, which is another Pinsent Mason's letter dated the 9th of April 2021. So it was therefore sent after the revenue rule trial, but before Mr. Justice Andrew Baker had handed down his judgment. And just to put this letter into context, by way of background, the parties were supposed to be agreeing a statement of agreed facts for what was described as the validity trial, and that was due to commence in Michaelmas term 2021. ED&F had produced a draft of the agreed statement of facts, and this was Pinsent Mason's providing a marked up response on behalf of SCAT. And at page 355, you can see the addition that's being made there with a new text at the very bottom, and you will see that it is stated, often for reasons not yet pleaded or explained by ED&F and MAN, Volcafe was interposed between PP buying, selling the shares and Iron Funds buying, selling the same shares. Volcaf was involved in the 80 Annex E WHD reclaims that ED&F MAN has conceded was made in error, with no shares having been acquired by the relevant PP. Now, Volcaf was an interdealer broker owned by ED&F, and that doesn't matter for present purpose, but I highlight this passage as making it crystal clear that SCAT was already positively asserting that no shares had been acquired by the underlying client. So let me then move now to the judgment. The revenue rule trial was heard between the 22nd and 25th of March 2021, and judgment was handed down on the 27th of April. And you can find that judgment, if you can turn to it please, in the judgments bundle at tab 2.
And the supplementary bundles can go away, or
Yes.
are you coming back to them?
For the moment anyway.
Yeah.
And you can, just if I can make 3 overarching points before we look at the detail. And it's just really to repeat the point I made a moment ago, but it's important. It was never suggested prior to the handing down of the judgment that the revenue rule might apply to some claims but not others. It was never suggested or argued that there was a distinction between negligence-based claims or fraud-based claims. There was no distinction between the causes of action alleged. The defendant were all in this together. No distinction was made between the defendants for the purpose of the application of Rule 3. And because of this, not all the defendants could contribute to the argument. So, for example, my clients did not make oral or written submissions at the revenue rule. You can see the representation at J20. So we were no-shows. And you can see that, but it clearly, as you've seen from the CMC order, all the defendants were bound. And you can see that the how SCAT put its argument, summarised by Mr. Justice Andrew Baker at 179 to 184, which is in the appendix. If you could turn to page 70 of this bundle. In fact, it's at page 69. You can see that there was an appendix called the Rival Contentions on Dicey Rule 3. And so what the judge has done there is in the appendix, set out the various arguments that were being made by the parties rather than putting them in the body of the text. I won't go into these in detail, but you can see from paragraph 179 of this document, which sets out SCAT's position, that SCAT put its argument summarised there, and it goes on, that the claims were of the same character as could be brought by a private law entity in response to fraud, false representations of fact, or otherwise by mistake. And at paragraph 180, ED&F MAN is lumped together with the other defendants on the basis that the transactions or purported transactions did not result in the beneficial ownership of shares required for a WHT transfer. And then
Just before you do,
Yeah.
so I'm absolutely clear. Going back to J20, where you get the list of appearances, is this right? Looking above the line, the other defendants did not appear and were not represented. It records that ED&F MAN Capital Markets Limited were represented by their solicitors.
they didn't speak, they were there as observers.
Yes, that's
I should have made that clear. Thank you.
And you didn't put any, you had the right to put in written submissions,
But we
you
didn't.
didn't do so.
Yes. I apologise for that mistake of mine, but that is the position. So the second overarching point, before we look at the detail, is that you will, if we turn to paragraph 5 of the judgment at page 22, you can see how the disputed issues of fact were dealt with. And as you can see, it was SKAT's argument that Mr. Justice Andrew Baker ought to proceed on the basis that SKAT would prove its case based on the way that the revenue issue had been defined. In the event the judge did not find it necessary to resolve contentious matters of fact, as we will see in due course, the judge did not think that specific trading patterns were of any relevance to the issue that he needed to decide. And you can see also the third overarching point, that there was common ground between the parties on a number of points. And for this purpose, if your lordships could turn please to paragraph 17, where the following high levels of statement of principle were agreed, and just going through them in the order. The first Roman numeral 1, it was agreed that the revenue rule was not a rule of jurisdiction, but a substantive rule of substantive rule of English law. And the next one, the revenue rule looked at the substance of the claim rather than the form, looking past the cause of action pleaded. And that's obviously important when one sees, such as Bright's analysis, the emphasis on the cause of action. Here it's stated to be common ground that it's a matter of substance, not form, looking past the cause of action pleaded. And then going on to 4, the question of whether Dicey rule applied involved a question of characterization. That's obviously a very important, because he refers repeatedly to the question of characterization for any given claims, rather than it is a claim to directly or indirectly, to enforce directly or indirectly Danish revenue law. And then there's one other point of common ground, which is not in that sequence of paragraph 17. But if the court turns to paragraph 18, you'll see at the bottom there, the last sentence, this was also common ground. If your lordships could just look at paragraph 18, where it says that it follows that Dicey Rule 3 is not avoided because SKAT's claims were for damages, personal restitutionary remedies, or proprietary remedies in respect of traceable proceeds, and the defendants are not the WHD refund applicants themselves. Dicey Rule 3 would apply to a damages claim against a party involved in the submission by a taxpayer of erroneous tax returns or in a tax evasion scheme for that taxpayer, even if the defendant's conduct involved all the ingredients of a private law cause of action, such as damages claim for a tort, because in substance the claim would seek to enforce the underlying right to tax the miscreant taxpayer. Likewise, if Dicey Rule 3 would apply in the case of tax refunds wrongfully claimed for the foreign sovereign's claim against a refund erroneously paid, then a claim by the foreign against those culpably involved in the making of the claim is equally inadmissible in this court. And then it's stated to be a matter of common ground. My third overarching point is that the judge, Mr. Justice Andrew Baker, was fully aware of the distinction between ED&F as a defendant accused of negligence and the other defendants accused of fraud. However, that had no impact on his analysis. And this is evident from paragraph 30, which is at page 28 of the bundle, where it says that SKAT reminds the court often that it claims to be the victim of fraud, not only of negligent or unblameworthy conduct, not so as regards the ED&F man applicants where fraud or dishonesty is not alleged at all. But in any event, in my view, the fact that in some of its causes of action against some of the defendants, SKAT alleges fraud or dishonesty by those defendants, or by others in circumstances that are said to result in a liability on the part of those defendants, does not assist SKAT on the characterization issue raised by Dicey Rule 3. And then so paragraph 30, therefore, contains the judge's unequivocal statement that the presence of allegations of fraud in some causes of action, while negligence alone is alleged, does not assist SKAT on the characterization issue. And the key issue that he had to determine was how to characterize SKAT's claims, whether covered by the revenue rule or not. And that point was carried forward into paragraph 31, where Mr. Justice Andrew Baker addressed SKAT's characterisation of its claim. SKAT argued that its claim to recover money wrongly paid out of a tax authority due to misrepresentation should not be characterised as a claim again under a foreign revenue rule. The defendants argued the contrary. And the point is that really at the end of that last sentence, the point now is that the formulation of the rival contentions, and thus the question of characterisation, has no reference to the nature or degree of any fault required for liability upon any given cause of action relied upon by SKAT under the system of law that in general governs it. And this is then reiterated in paragraph 32, where the judge says, the learned judge says this: a plea to the character of the wrongful act by reference to the nature or degree of fault involved in it, or any consequent lack of sympathy the court may be invited to have for the defendant pursued abroad by the sovereign claimant, or sympathy for the claimant, has never been admitted as relevant. And then there's a reference to the Buchanan case. And then the learned judge ran through the authorities on the revenue rule. I don't think it's necessary to go through them, but we can perhaps stop off at paragraph 51, which is at page 35 of the bundle. So paragraph 51, page 35. And here Mr. Justice Andrew Baker is commenting on Lord Mackay in Williams and Humbert and his reading of the early authority cases of Buchanan. And in paragraph 51, Mr. Justice Andrew Baker says in the first part of this paragraph that the analysis supported the defendants that, subject to the prior question, which is the real question here, whether SKAT's unsatisfied claim to recruit what it is paid out by mistake is to be regarded for the purposes of Dicey Rule 3 as a revenue claim. So the focus then is on the payment out by mistake. The focus is not payment induced by fraud, because we know the cause of action is irrelevant, according to Mr. Justice Andrew Baker, nor does it depend on any particular trading structure used by any of the defendants. Instead, the question is how to characterise SKAT's claim to recruit what is paid out by mistake. And at the end of paragraph 51 is also relevant, where the judge states that Lord Mackay cannot sensibly be taken to be expressing a view on the point raised in this case, and not raised or considered in Williams and Humbert, which is whether, as the defendants say, there is no material distinction for the purpose of Dicey Rule 3 between a claim for tax due and unpaid and a claim for the return of a tax refund mistakenly granted and paid. So I then turn to paragraph 71, which is at page 41 of this bundle. And the first sentence of this paragraph records the argument by SKAT on fraud. The framing of the claim does not by itself take the claim in question outside the rule. So he says, I do not understand Mr. Feely, who was representing SKAT at that stage, to submit that where SKAT alleges a fraud or conspiracy, that without more, i.e. the mere fact that SKAT so frames the claim, takes the claim in question outside Dicey Rule 3. And then at paragraph 75 of page 42, this is an important part of the judgment, which is in fact quoted by the Chancellor in his judgment. And this contains findings of law. And the one that I want to stress for present purposes is the point at Roman numeral 3, where the learned judge says this: the substance of the claim is not determined by the private law causes of action pleaded. Indeed, the relevant issue of substance over form arises at all only when and because the claim is framed in that way, that being a matter of form in this context, as the identity of the claimant, though that aspect does not arise in the present case. And then at 4, there's this emphasis that really is the main part of the judgment, rather that the substance of the claim is determined by the central interest in bringing the claim of the sovereign by whom it is brought, or in whose interest directly or indirectly it is brought. And then paragraph 5, the mechanism by which harm is said to have been suffered in respect of which a claim seeks reparation is material to consider and may be important in judging whether the essential interest in bringing that claim is a sovereign governmental interest rather than a patrimonial private law interest. And as we will see, this refers to the use of tax vouchers, not to the mechanism of the underlying trades. And then the judge applied his analysis of the revenue rule to in a section which is starting at paragraph 76, which covers all the features of SKAT's claims. And so it's these paragraphs that are effectively the meat of the decision. But rather than read them out at this stage, what I would like to do is just highlight 6 matters which we say come out of this analysis. The first is, as your Lordship see from paragraph 76 on this page, but it also comes out from paragraphs 81 and 83. The Danish WHT Withholding Tax Act provides the foundation of SKAT's claims. Without it, SKAT's claims could not exist.
Right, SKAT's claims as pleaded.
As pleaded. Yes, I'm happy to do that. Repeat that. SKAT's claims as pleaded. Second, at paragraphs 84 to 86, Mr. Justice Andrew Baker compared SKAT's claims with other ways in which it might be defrauded through cyber attacks and the like. But at paragraph 86, he notes that every cause of action starts with and must be pleaded by reference to the delivery of a completed form 06.033. That's the tax voucher. And this is why Mr. Andrew Baker was focused on the factual mechanism of the tax vouchers as an important feature of the case. The third point, in relation to how far Mr. Justice Andrew Baker's analysis goes, we need to look at paragraphs 89 and paragraph 90. Paragraph 89 at page 45 highlights the scope. Mr. Justice Andrew Baker is looking at recoveries in respect of a tax refund payment made through error induced by misrepresentation. And he goes on to say, as we've seen before, that whether the misrepresentation was fraudulent or negligent is beside the point. And one type of misrepresentation is put to one side by the learned judge in paragraph 90. If you can look at that, and here you can see that he does not address misrepresentation as to identity. In other words, if a payment was made to party A intending it to go to party B, the judge says that other considerations might arise. Now, my learned friend in his skeleton argument at paragraph 38 says that this undermines our reliance on issue estoppel, as the judge did not rule that all claims by SKAT for compensation in respect of tax refunds would inevitably fall foul of the revenue rule. But our starting point, of course, is that this is irrelevant because no question of misrepresentation of identity arises in either the old or the new case. More generally, this paragraph 90 is relevant, we say, in establishing what Mr. Justice Baker held to be the fundamental basis of the decision. And we'll go through this when we look to see what the essential point is and to go through what is fundamental and what is ancillary in this first judgment. And the decision is clear, we say, apart from misrepresentations as to identity, with which we're not concerned with, all misrepresentations of the type he was concerned with, i.e. anything that goes to the applicant's entitlement to a tax refund for which they're applying, is the focus of the attention. The fourth point is that we have the judge's conclusions as to how claims to recover the funds tax refunds should be characterised, and that's at paragraphs 94 to 95. And we can see that the conclusion is that the taxations of dividends under the WHT Act is in substance a single exercise of sovereign authority to take in tax a proportion of declared Danish companies' dividends, and that's at paragraph 95, just below letter C. Then we go to 97, which is important because it's said that SKAT was seeking to enforce its entitlement to keep as tax what it had collected up front by operation of the WHT scheme. Paragraph 98, SKAT's claim seeking to recovery in respect of a tax refund made through an error induced by misrepresentation is by nature conceptually and functionally the same as a claim for tax due and unpaid. You see that at the very bottom of that page. And then the final words on this paragraph are, and going over the page, it is in substance a tax claim. And then paragraph 99 returns to what was my second point, which was the mechanism used for tax refunds. And again, we can see from paragraph 99, what the judge says is this, the learned judge says is this: the substance of SKAT's claims is, in my judgment, that by conduct of a kind ordinarily regarded as actionable in tort, the defendants have diverted from SKAT amounts to which it was entitled as dividend tax on Danish corporate dividends. And this is the key passage. The mechanism by which that was done on SKAT case was that of WHT refund applications, that SKAT was misled into accepting and paying. But in the context of Dicey Rule 3, that is a matter of form. And then the final sentence of paragraph 99 leads me on to my fifth point, which is the judge's focus on SKAT's interest in bringing the claim as a sovereign right. And we see that again at paragraph 102, where he talks about the real and central interest of SKAT in bringing its claim against ED&F man is to seek to repair the hole in the finances. And we can also see this from paragraph 107, in that SKAT's dividend tax take, and where the judge says that at 107, the mechanism of alleged wrongdoing then may be the making of WHT refund applications conveying misinformation, but the central interest of SKAT in bringing the claim and the right that in substance SKAT seeks to enforce by that are in point of form private law claims is SKAT's interest and right in collecting what was due to it by way of dividend tax for the tax years in question. Dicey Rule 3, a mandatory rule of English law as lex fori, has the effect that there is no cause of action for a fraud on a foreign revenue, and I agree with the defendant's submission that at its highest, SKAT here claims here to have been a victim of the fraud. It cannot sensibly say in relation to claims pursued here that it was a victim of a fraud such as might be committed against a private individual or corporate entity. A fortiori, there is no cause of action for negligently causing loss to the foreign revenue. And then my sixth point, I think my last point, relates to how we should deal with paragraphs 109 to 112, where we have the judge addressing some specifics of SKAT's allegations against defendants other than ED&FM, though he notes the position of ED&F in parentheses in paragraph 110, and in particular that SKAT had alleged that those other defendants, that the transactions were sham, involved closed loops of transactions in which no one could obtain any interest in shares. And in paragraph 112, he said that does not, in my view, alter the proper characterization of SKAT's resulting claims for the purpose of Dicey Rule 3. It remains the case that their fundamental premise is SKAT's contention that the WHT refunds sought and paid. SKAT is still in substance seeking to recover compensation for making tax refund payments that it was not obliged to make from the perspective of Dicey Rule 3. Those are, in my view, foreign revenue claims. And your lordship can see the same point comes out of in the paragraph 114, where the judge says this: the strongest version of SKAT's case, alleging that the transactions were not contracts at all, is ultimately just a particular way of accusing the WHT applicants of having not merely claimed incorrectly to be limited Danish tax eligible for a tax refund, but pretended to be as such, i.e. made that claim knowing it to be a false claim. That does not change the character or quality of SKAT's relevant activity. in accepting and paying the WHT refund claim, and now in claiming to reverse the same, even if point of form that claim is presented by reference to the ingredients of private law causes of action, SKAT was and is acting as a Danish sovereign tax authority in the interests of the Danish fisc, and not as a private party could or might act. The central interest in pursuit of which SKAT brings these claims remains that of taxing Danish company dividends properly, accurately in accordance with the Danish tax law and DTA's a purely sovereign interest. And then we then get to paragraphs 118, which is the conclusion on the revenue rule trial, namely that the claims are all revenue rule claims. And then at paragraph 119, it contains a conclusion that although SKAT framed its claims as private law causes of action, those claims all sought payment to SKAT of amounts of dividend tax it fails to take in the tax years in question. And in line 6 to 8, he says expressly that SKAT's claims were in substance claims for tax and not admissible in the English court. He then says that the central interest in SKAT bringing its claims is to vindicate its right to pay WHT refunds only where eligibility conditions are satisfied. And then we get at paragraph 120 the conclusion that SKAT's claims seek indirectly to enforce the Danish tax law. So we say that the essential steps in this judgment are, in terms of the forms of action, the specific forms of action are held to be irrelevant, and your lordships can perhaps just turn to the Court of Appeal judgment where the Chancellor delivered the judgment, and you can see that how the judgment below was considered, and this is in the page 102, yes, paragraph 19, where the Chancellor quotes paragraph 17, which we've already looked at, and paragraph 12 at page 104. Your Lordship can see the reference to the conclusions at 118 to 120. So in other words, the cause of action is irrelevant. The second point is the characterization of SKAT's claims is critical. The core issue was how to characterize the claims, and the learned judge concluded that SKAT was acting as the Danish Sovereign Tax Authority seeking compensation for tax refunds that it was not obliged to make. And the Court of Appeal, the Chancellor, at paragraph 10, at page 103, quotes paragraph 75 of the judgment below, and at paragraph 11, your Lord can see the references to paragraph 89 and paragraph 90 that we looked at a moment ago. The third point is the public function. SKAT was acting in the interests of the Danish fisc and not in a matter akin to a private party, and that was an essential part of the judge's analysis, explicitly affirmed in the Court of Appeal's judgment in terms of the analysis, the repetition of paragraphs 118 to 120 at paragraph 12, and then the foreign revenue claim in the revenue rule. He held that all SKAT's claims for compensation arising from tax refunds were foreign revenue claims barred by the revenue rule. No distinction between the various claims, and your Lordships can see that the Court of Appeal, the Chancellor at paragraph 13, quoted passages that I've referred to, and of course the key paragraph in the judgment is paragraph 119 of the judge below, which is quoted, I think, at paragraph 12 earlier, where the Court of Appeal quoted the judge's key reasoning at paragraph 119, highlighting that there is no distinction to be drawn between unpaid dividend tax and tax conditionally collected as WHT but refunded. All claims for the return of WHT refunds were in substance claims for tax and therefore inadmissible.
Sorry, I lost you there. Where are you reading?
It's at 119.
See,
Just
yes.
going back to
Yes,
remind you
yeah,
what was said there.
Yes.
Now, just to complete the judge's analysis, just so that is that the judge also dealt with a point on the Brussels-Lugano as to whether or not that affected the applicability of Dicey Rule 3. And essentially there were two arguments. The first was whether or not Dicey Rule 3 survived Brussels, and the judge followed Dicey and Morris. But then there was this other issue as to whether or not this was a civil or commercial matter, and the judge said it was a civil and commercial matter. Now, as you know, when it went to the Court of Appeal, this in fact was the only point upon which the judge gave permission to appeal. The courts came to the conclusion that it was not necessary to deal with the question of civil or commercial, but essentially following the reasoning of the judge below, the court said that this was not a civil or commercial matter as against my client. It was a revenue matter. So effectively applying the reasoning of the Court of Appeal, which it disagreed with in relation to the other defendants, but as far as my client was concerned, this was a revenue matter. And at this point was referred to in terms of the Brussels-Lugano issue at paragraph 170 at page 56. My Lord, I don't know, is it the practice of this court to take a break or not? Or do you?
It isn't normally, unless
Okay,
I
I'm fine.
specially asked for one.
I'm not asking. I'm fine. So then we come to the events after the revenue rule judgment. And you will recall that by the time of the revenue rule trial, SKAT had intimated claims of dishonesty, perfectly aware of the Annex E tax vouchers involved purchasing shares from ED&F in Dubai, which had been acted as a naked short seller. And this is also clear from what happened after the judgment. And you can see that it asked the learned judge for permission to appeal. And if we could pick up again the supplementary bundle 2 at tab 34. This is at page 358, I think it is, tab 34. This is the skeleton argument, and the only point, the grounds of appeal. You will see that ground 1 was about Dicey Rule 3.1, and what is said is that at paragraph 12, your lordships can see that SKAT only pursues ground 1 only in relation to that part of its case which concerns WHT refund applications, which SKAT alleges were made by applicants who never owned any shares and never received any dividend from a Danish company, and are therefore never liable to tax and in fact paid no tax to relevant applications. That amounts to 96.7 by value, including the ED&F man applications in Annex E, but excluding all other ED&F man applications. So this is the first time that we see a distinction in the claims alleged against ED&F man. And the point is that they said we want permission to appeal, but only in relation to Annex E, but not the rest of its claim. And this passage also shows that it concludes by this stage in respect of the Annex E tax vouchers that the clients never owned any shares and never paid any tax. Now, this is a bit odd because you recall that SKAT also alleged that there was no beneficial ownership of shares in the non-Annex E tax vouchers But anyway, that was SKAT's stated position. The learned judge did not give permission to appeal on ground 1, though he gave permission, as I mentioned a moment ago, on ground 2, which concerned the point about civil and commercial and whether or not how that was affected by the Brussels regulations. Now, after that, SKAT renewed its application for permission to appeal to the Court of Appeal. At that stage, however, it dropped ED&F man entirely from ground 1, but only pursued ground 2 against ED&F-M. So we got to the Court of Appeal hearing where Mr. Justice Andrew Baker's judgment was now set in stone, we submit, on ground 1 against ED&F-M. And you can see what happened at the Court of Appeal. If we can turn to the supplementary bundle at paragraph 36. At 362. And this is an extract of the transcript. It's not immediately obvious from this transcript, but Lord Panic, King's Counsel, made most of the submissions on behalf of SKAT. But Mr. Feely, King's Counsel, however, was asked to deal with the question of why SKAT was approaching ED&F-M differently from the other defendants. And that discussion starts. If we can look at the internal numbering, in effect the first column, it says page 9, you can see at the top there, line 14, where the Chancellor asked the question, and that's where the discussion starts, saying that it would be of great assistance to the court to have some clarity on why ground 1 was not being pursued against ED&F-M. And SKAT's answer at paragraph 22 of the same page was that it had taken a pragmatic approach and focused on its fraud claim. Now, pausing there, the learned judge held in our case at paragraph 92 that SKAT already had in its minds to bring a fraud claim in the near future when that hearing took place. So if it was pragmatic in the sense that they knew they were letting out a defendant that they suspected of fraud. I'll come back to that passage in Mr. Justice Bright's decision in a moment. But SKAT's counsel also suggested at the top of the internal page 12, which is on the other side of the page, that the claim of ED&F-M was approximately, and this is lines 4 onwards, 5% of the total value of the claim. It described this as, quote, a very small aspect of the case quantum-wise. The upshot of that, as we can see from the final words on this page, was that Lord Justice Stuart Smith commenting that the Court of Appeal was bound to treat the ED&F-man transactions as falling within Dicey 3 in this court for this appeal. And turning over the page, at the bottom of internal page 13, the Chancellor returned to the question of why a different approach had been taken, and that led into a discussion of the re-amended Schedule 5T, which you will recall was SKAT's case against ED&F-M. And if you get to the end of that discussion at page 364 of the bundle and look at eternal numbering 19, you can see SKAT's summary of that correspondence that we looked at, where what is said that since the pleading was settled in the winter of 2019, in a letter of January 2021, ED&F-man solicitors have told us that in respect of these transactions, the Annex E transactions, its client's counterparty in the trades purportedly underlying the Annex E transactions was a related ED&F-man company, namely ED&F-man Proprietary Trading Dubai Limited, that ED&F-man Dubai entity was in fact short selling, but it did not have the right to the relevant shares of the trade day. It had received a dividend, and correspondingly its purported client had not received a dividend, albeit they say that they had received an equivalent amount, the net dividend, albeit from ED&F Dubai, not from the Danish company. Now certainly we would say as regards those shares on the basis of that letter, but I have to accept is not in the pleading of the winter of 2019, there were no shares in the sense that they were buying from the naked short seller who was not able and did not settle by means of a delivery of shares, but instead handed over what is known as a manufactured dividend, a sum of money equivalent to the sum of money that would have been received from the Danish company. So in terms of not pursuing the appeal against ED&F, you can see here that SKAT did so knowing that the Annex E tax vouchers relied on trades with the Dubai entity when that entity was a naked short seller. And what you do not see in this transcript, because it's not mentioned to the Court of Appeal, is any indication that SKAT was continuing to investigate fraud against ED&F. And this is despite the fact that SKAT was doing so in the US proceedings and had received Mr. Wade's report a few weeks before this hearing. And as we will come on to in our abuse case, we say that Mr. Justice Bright ought to have found that SKAT could and should have pleaded fraud long before this. But even on Mr. Justice Bright's conclusion, this conversation between counsel and the bench took place at a time when SKAT knew that it was in a position to plead fraud, and the Court of Appeal should have been told that SKAT had in mind to bring a claim in the near future. And if we can look at the judgment below of Mr. Justice Bright at in the core bundle at tab 6, page 87. At paragraph 92, what the judge says this, 4 lines bottom, Mr. Malik says, and I agree, that in the interest of transparency and candour, the Court of Appeal should have been told that while the case as alleged in the original proceedings did not include fraud, SKAT had in mind to bring a fraud claim for the tort of deceit in the very near future. So Mr. Justice Bright concluded that SKAT had actively intended to start against ED&F, but did not mention this to the court. And as we will see later, some of the case law refers to a party keeping a card up its sleeve, which we submit covers this. But in any way, the effect of this...
At some stage, this is presumably not when you're going to do it, you'll tell us what difference it would have made had Mr. Feely told the Court of Appeal, actually, although we've only pleaded negligence so far, we are considering bringing a fraud claim.
Yes, which would have even cast into more doubt the inconsistency that the Chancellor saw in their position as to why aren't you, why have you dropped ground 1 against the against ED&F? Doesn't make any sense. But anyway, the effect of not appealing ground 1 against ED&F man was clear to the Court of Appeal. It means that SKAT was bound to accept that its claims on the 420 tax vouchers that it relied upon was subject to the revenue rule. And there's an oddity here at paragraph 90.
Sorry, we're in paragraph 90 of the Court of Appeal.
Of Mr. Justice Bright's decision,
yeah,
which is worth just looking at briefly, yes, which is at page 87.
Yeah.
So what he said is that they get the report of Mr. Wade in the US proceedings. That is when SKAT could have pleaded fraud, and it is not when SKAT should have done so. In England, SKAT still faced the problem that until the judgment of Mr. Justice Andrew Baker on the revenue rule was reversed by the Court of Appeal, there could be no case against ED&F man at all. So that seems to accept that unless the decision of Mr. Justice Andrew Baker was reversed, it will be bound by his decision. In other words, that there would be an issue at estoppel. But presumably the judge didn't mean to say this because he'd already found that there was no issue at estoppel.
Well, presumably what he meant was that under Mr. Justice Andrew Baker's ruling, you couldn't bring a claim in fraud if your claim was of this type. It was still caught by Dicey Rule 3.
Yes.
So presumably, subject to the appeal, he struck out all the claims against everybody.
Correct.
So there's nothing to amend at that stage.
Yes, I can see that.
It's gone, subject to it being reinstated on appeal, which is what happened.
Yes. But I mean, the point I'm making here is that having chosen not to pursue ground 1 as against my client in circumstances where there is no difference between the causes of action and there being no appeal. We have to look at this when we look at the issue of estoppel, which we say arises. We say they're stuck with that decision. And the logic of the Andrew Baker decision, although the Court of Appeal disagreed with it and overturned it, it still had to be applied to my clients because of the lack of an appeal. And you can see that in the Court of Appeal's judgment, where the court concludes that Mr. Justice Andrew Baker's decision was wrong, but it saw no issue with holding SCAT to its decision not to appeal on ground 1 against ED&F. And we will see that from the Court of Appeal judgment. If we turn to the judgments bundle at tab 4, at 145,
Paragraph 145.
yeah, paragraph 145 at page 139, where the judge says, because the Chancellor says, because SCAT has not pursued ground 1 against ED&F man, this court does not need to determine whether the same analysis as the one I have adopted in respect of a claim founded on fraudulent misrepresentation would apply to a claim founded on negligent misrepresentation or mistake. Without deciding the point, since we do not have to, and it would be invidious to do so, given the concession SCAT makes against ED&F man, it does seem to me that where the claim is against a defendant who has obtained a refund by misrepresentation, even if not fraudulent, to which it was not entitled because it was never a shareholder, never received a dividend, and was never a taxpayer, there is much to be said for the conclusion, which seems to have found favour with the New York State Courts in Rosenthal and Nafadsky, that in those circumstances the revenue rule should not apply. Now, what Mr. Justice Bright said at first instance at paragraph 20 is that I've got a false read. I'll come back to that. But what is clear is that it's pretty obvious from this that the Court of Appeal would have concluded that the ED&F claims were not barred by the revenue rule. But that's irrelevant because ground 1 was not before the Court of Appeal. And in respect of ED&F man, and so the issue of estoppel arises from Mr. Justice Andrew Baker's decision and obviously not from this judgment. Yes, and that so. But however, if we look, we then turn down the page, going back to the Court of Appeal, which is at judgment page 139. What the Chancellor says is this: given that SCAT has not appealed ground 1 against ED&F man, as I've already noted, SCAT has to accept that as against those defendants, the claim is inadmissible by virtue of Dicey Rule 3, unless it can satisfy this court. 1, that the claim is a civil and commercial matter, not a revenue matter, for the purposes of Article 1 of the Brussels Recast Regulation, and 2, that the operation of Dicey Rule 3 is precluded because, contrary to the judge's analysis, it would impair the effectiveness of Brussels Recast Regulation. Then at paragraph 150, the Chancellor said this, page 140 internally: whatever the reason for SCAT not having pursued ground 1 against ED&F man, and although it was said that it was done for reasons of pragmatism, as I've already said, there does seem to be an inconsistency of approach. SKAT is fixed with the judge's conclusion that as far as ED&F man concerned, Dicey Rule 3 makes the claim inadmissible. It must follow that either so far as those defendants are concerned, the revenue rule applies, or the claim involves the exercise of assertion of a sovereign right. Whatever the test for the application of Dicey Rule may not be identical to that for determining what is a revenue matter for the purposes of Article 1 of the Brussels Recast Regulation, it can be seen that its application leads to the same answer. If Dicey Rule 3 applies, as SKAT has to accept it does in relation to the claim against ED&F man, then by either a right which arises from the exercise of public powers or a legal relationship characterised by an exercise of public powers from which it necessarily follows that the claim is a revenue matter outside the Brussels regulation. So what we see here is the issue estoppel we rely upon applying here in the Court of Appeal. There's no appeal on the revenue rule, so the revenue rule applied. It appeared to the court that that SKAT's position was inconsistent, but that SKAT had made its bed, so it had to lie in it. And so that's where we are, and I now want to look briefly, if I may, at the authorities on issue estoppel. Now, in our skeleton argument, we undertook an analysis of the revenue rule judgment. By contrast, SKAT's skeleton argument provides little more than an acknowledgement of the judgment's existence, asserting that it dealt only with the application of the revenue rule to the facts alleged by SKAT in that case, and on that basis it contends that an issue estoppel could not arise. Now, we say that if SKAT's position were correct on that point, it would be difficult to see how issue estoppel could ever arise between two sets of proceedings. Any judgment is necessarily concerned with the facts as alleged by the parties in the case, and it would always be possible to plead some new fact to distinguish the two. However, as we submit, the authorities show that this narrow approach adopted by the learned judge below, Mr. Justice Bright and SKAT, misapplies the law. The proper analysis requires consideration of the essential steps of Mr. Justice and Mr. Andrew Baker's reasoning to determine whether those same steps are engaged in the facts of the present case.
Since that sounds like an important proposition, can I just have it more slowly so that I can take it?
Yeah, we said the proper analysis requires consideration of the essential steps in Mr. Justice Andrew Baker's reasoning to determine whether those same steps are engaged by the facts of the present case. My Lord, as far as the elements of issue estoppel are concerned, it's not controversial to say that there are 4 requirements, perhaps 3, but one of the requirements relates to estoppels arising out of foreign proceedings, which obviously what we're concerned is. But I mean, the requirements are clear. The first is that there must be a final and conclusive judgment on the merits in some prior action. And in this case, that final judgment is the judgment of Mr. Justice Andrew Baker. Once the appeal again was dismissed, it was therefore final and conclusive. The second requirement probably is not relevant, but it clearly must be by a court of competent jurisdiction. Again, that's not in dispute. The third requirement is that there must be identity between the parties to the same actions or their privies, and we have precisely the same parties in this case, SKAT and my client, so that does not give rise to any issue. And then the fourth is that there must be identity of subject matter in the 2 proceedings, and that's the crucial point upon which this appeal turns. Now, there are some aspects of issue estoppel principles which do not arise in this case. The first is that we rely on what the learned judge explicitly found, so we're not relying on inferences as to why he reached a particular result, so that point doesn't arise. And the second point is, for the purpose of the issue of estoppel, we rely on the arguments that were made before the learned judge, not arguments that could have been made or should have been made. So in other words, we're dealing with explicit findings, and we're dealing with arguments that were made and not arguments which could and therefore should have been made. Now, in terms of the doctrinal basis of the doctrine, the leading case remains the Virgin Atlantic case, and if we could look at that briefly, in the judgment of Lord Sumption, it's in the authorities bundle, tab 15, page 548. The facts I don't think matter, but in essence it involved English proceedings upholding the validity of a patent where the patent was subsequently amended with retrospective effect by the European Patent Office, and the question for the Supreme Court was whether an inquiry as to damages should proceed on the basis of the patent as found to be valid by the English proceedings or as amended. And it's against that background that you can see at paragraph 17, with whom the rest of the court, I think, agreed, deals with the principles behind res judicata, where he says that paragraph 17, this is page 548 of the judgment, where he says that res judicata is a portmanteau term which is used to describe a number of different legal principles with different judicial origins. First, he addresses cause of action estoppel, where an outcome of a cause of action cannot be challenged, and at letters F and G, he refers to issue estoppel, and Henderson abuse as further principles under the heading of res judicata. I mean, that passage is fairly well known, but just if you may just glance at the F, the fourth proposition, where he talks about some issue which is necessarily common to be decided on an earlier occasion and is binding on the parties, referring to the Duchess of Kingston's case. And then paragraph, page 550, paragraph, he refers to the judgment at the top there of Arnold and National Westminster Bank, and the speech of Lord Keith of Kinkell, where this is said, and this is just above D, cause of action estoppel arises where the cause of action in the later proceedings is identical to that in the earlier proceedings, the latter having been between the same parties or their privies and having involved the same subject matter. In such a case, the bar is absolute in relation to all points decided unless fraud or collusion is alleged, such as to justify setting aside the earlier judgment, the discovery of new factual matter which could not have been found out by reasonable diligence for use in the early proceedings does not, according to the law of England, prevent the latter to be reopened. And then this is said about issue estoppel. Issue estoppel may arise where a particular issue forming a necessary ingredient in a cause of action has been litigated and decided, and in subsequent proceedings between the same parties involving a different cause of action in which the same issue is relevant, one of the parties seeks to reopen that issue. Now, in terms of the underlying policy to these various doctrines, it's convenient to turn to page 552, at letter F, where we can see the often quoted dictum from Johnson and Gore Wood, which can also be found in the, and the point I would draw from this dictum is that cause of action estoppel, issue estoppel, and Henderson all share a common underlining in the importance of finality in litigation, and that a party should not be twice vexed in the same matter. In essence, although it's talked about in terms of a public interest, in my respectful submission, there are two public policy reasons there. The first is finality. This prevents the legal uncertainty that results from re-litigation, and to prevent the waste of time and resources that would involve. And the second is that an individual should not be vexed twice for the same dispute. This is about avoiding uncertainty. It avoids the abuse of grinding down opponents through the process of forensic attrition. And then if we then turn over to 553, letter G, we can see Lord Sumption saying this very much the same in terms of policy, where he says that res judicata and abuse process are juridically very different, and in my view there are distinct, although overlapping, legal principles with the common underlying purpose of limiting abusive and duplicative litigation. Now we've seen that Lord Sumption referred to the Arnold and National Westminster decision of the House of Lords, but there's a couple of points that I want to bring out from that case. And so if your lordships could then turn please to Authorities Bundle 1. Tab 8. This is 202. And just by way of an oral head note, that was the case where a landlord had obtained judgment from Mr. Justice Walton on the proper rent payable under a rent review clause based on assumptions beneficial to the landlord. As that first dispute arose out of arbitration and Mr. Justice Walton refused permission to appeal, the tenant was stuck with a high rent for several years. In the meantime, in other cases, Mr. Justice Walton's decision was held to be wrong. The rent came up for review again, and the tenant applied for rectification of the lease, but was faced with an argument of issue estoppel to the effect that Mr. Justice Walton's construction should be used again. And so the question in that case was not whether the question of construction was the same, it plainly was, but whether the tenant could escape from the application of the previous judgment by relying on special circumstances in the form of a change in the law. And there are three dicta in the speech of Lord Keith that I briefly want to pick up. The first is at 215 at letter B, where a judgment of Lord Justice Diplock, as he then was in Fidelitas and Vio Export Club, is cited in 1966. And as you can see, it refers there to an interlocutory judgment, and yet Lord Diplock says that the parties remain bound by a decision and that an issue of estoppel, and that a party's remedy lies in an appeal. And obviously our case involves a preliminary issue, which did in fact resolve the proceedings as against my client. But this passage from the judgment makes clear the point that's not in dispute, that a preliminary issue can give rise to an issue of estoppel, and this is an example of it. The second dictum is to pick up what is said at paragraph 216 of this judgment at just below letter D, where Lord Keith is referring to Carl Zeiss, where Lord Reed had been concerned about how issue of estoppel arising out of a trifling claim but binding a party in a much more important set of proceedings. And I note that because our case is the opposite of that spectrum. We obtained judgment after a 4-day preliminary issue trial where SKAT was claiming for very substantial sums. So there's no suggestion of the unfairness of applying an issue of estoppel in a case such as our case. And then over the page, at page 217, there was a quote again from Lord Justice Diplock, as he then was in the Mills and Cooper case at B to D, which is worth noting, if only for the fact that it states that the issue of estoppel applies, and this is sort of 3 lines into it, an assertion, whether of fact or of the legal consequences of fact, the correctness of which is an essential element of his cause of action or defence. If the same assertion was an essential element in his previous cause of action or defence in previous civil proceedings between the same. I don't think that this is controversial, but this statement makes it clear that issue estoppel can apply to a defence as much as it can to an element of a cause of action. And as well known, the House of Lords...
It says, if the same assertion was an essential element in his previous cause of action or defence, then he can be estopped. So what we're talking about here is whether SKAT is estopped.
Correct.
So it is whether there is something about SKAT's cause of action.
Yes.
It's not about SKAT's defence.
No, your lordship's right. Yes, I can see that.
But it's implicit in SKAT's claim that it's not barred by Dicey Rule 3. In other words, that the English court can hear it.
That it's admissible, yes.
Yes, but it's an admissible claim.
I see that. Your lordship's right to take me up on that point. But the one point that I want to just get out of the way is that this case is authority that there can be special circumstances which can override an issue estoppel. But in this case, it's common ground both before Mr. Justice Bright and before this court that SKAT does not rely on special circumstances. And if your lordships can turn to Mr. Justice Bright's judgment, where this is dealt with, it's at paragraph 36, where he makes a reference to Arnold, and where it said this, however, such special circumstances only arise in very unusual cases such as Arnold. Mr. Graham Kingstown did not suggest that this case presents such special circumstances. And in fact, if you turn to the next,
He says it again.
Yeah, it's rather like the Frank Sinatra song, New York, New York. So obviously
that's another pragmatic decision, is it?
Yes, yes. So anyway, so it's said twice, and in our submission, that is the position. But we say nor could SKAT assert special circumstances. I mean, the difference, of course, is that in the case in Arnold, the party was bound by the decision of Mr. Justice Wharton. And because it was an arbitration matter, there was no appeal. And therefore, one's dealing with events that took place after the appeal in terms of decisions. In our case, they made a conscious decision, recognizing that there was an inconsistency, and for reasons of pragmatism, that they did not want to challenge the application of the revenue rule to the causes of action as pleaded at that stage. So it's difficult to see how special circumstances could ever arise. And although there is...
You may or may not be right about that. Speaking for myself, I'm not entirely sure that if the result of the issue estoppel is that a judge has to be treated as applying a principle of law, which is not the law, that's not capable of amounting to special circumstances, even if that arises out of a decision made on appeal. But your point is that point was not taken before Mr. Justice Bright, and there's no respondent's notice on it, and that's just not open in this court.
That's correct. Thank you for that clarification. Now, can we then deal with this question about necessary or essential steps, matters that are not collateral? And what we say is that SKAT is precluded from pursuing its new claim in deceit against the for the following reasons. We say that an issue estoppel arises. In other words, while the decision of Mr. Justice Andrew Baker on the applicability of the revenue rule was overruled in relation to other defendants, that decision remains binding and unchallenged in relation to my client, and therefore the principle of issue estoppel prevents SCAT from relitigating the issue of whether the revenue rule applies to preclude claims against ED&F man specifically. As
Sorry,
that
can you just take this slowly, because I'm very interested in what you define as the same issue. The
Yes,
issue the issue of whether
the issue of whether the revenue rule applies to preclude claims.
Can we take it slowly? Revenue rule applies
to preclude claims against ED&F man specifically.
Is that all claims? Does that include new? You said there were 5 new claims.
Yes, we
Is
say.
there a difference between the 5 new claims and the 200 and whatever it was old claims? Would you say because they didn't appeal in relation to those claims, they now can't bring the 5 new claims either?
Correct. Correct. I mean, the new claims are essentially.
Sorry, just before you do that, I may have stopped mid-sentence, or that may be the end of the sentence.
Yeah, well, it prevents SCAT from relitigating the issue of whether the revenue rule applies to preclude claims against ED&F man specifically, as that issue was definitively determined and left undisturbed by the subsequent appeal. I will come back to this issue that my learned friend, Lord Justice Popplewell,
so you were going
identified.
to say more about the 5 new claims.
Yeah. And secondly, the distinction between my client and the other defendants is critical. Mr. Justice Andrew Baker's judgment, as it applies to ED&F man, conclusively determined that SCAT's claims were barred by the revenue rule, and that SCAT cannot avoid this outcome by reformulating its claims as one in deceit, because the same underlying issue, in other words, whether the revenue rule applies, remains central to its case. And in these circumstances, we say that the judgment of Mr. Justice Andrew Baker creates a final and binding bar to SCAT's deceit claim against ED&F man, irrespective of the appellate outcome for the other defendants. And therefore, the claim should be dismissed. Now, as I said, I'm going to have to go and look at this in the context of the various claims, but before I do so, I just need to look at some of the authorities which indicate what is an essential matter, what are the essential steps. And there's a few cases that are worth looking at. I mean, the first is Hoisted and the Commissioner of Taxation, and that's in the authorities bundle. Bundle, yes. First, authorities bundle 1, tab 2. And if your lordships could just glance quickly at the head note, it related to the treatment of 6 beneficiaries of a will. And in the first set of proceedings, the High Court of Australia determined that each of the 6 beneficiaries was entitled to a deduction of $5,000 from a particular land tax for the years 1918 to 1919, and then the following tax year, 1919 to 1920, the authorities sought to restrict the beneficiaries to a single deduction of £5,000, arguing that the question of whether the tax payments were joint owners was not something that had been disputed or determined in the first proceedings. And the Privy Council, allowing the appeal, rejected that submission and held that the revenue was required to give the 6 deductions of $5,000 consistent with the first decision, and the judgment of the Privy Council, with the opinion of the Privy Council, was given by Lord Shaw. And that we submit as a true case of an issue estoppel. The underlying facts were identical in the 2 issues, but time had moved on, and so the question focused on the liability in a different year of taxation. In other words, it related to a different cause of action, a different year. And the first dicta that brings this out is at page 20, of the authorities bundle at the bottom of the page, where it said this at the bottom of page 20. Very numerous authorities were referred to. In the opinion of their lordships, is settled first admission of a fact fundamental decision arrived at cannot be withdrawn and a fresh litigation started with a view to obtaining another judgment upon a different assumption of fact. Secondly, the same principle applies not only to an erroneous admission of fundamental fact, but to an erroneous assumption as to the legal quality of that fact. Parties are not permitted to bring fresh litigations because of new views they may entertain of the law of the case, or new versions which they present as to what should be a proper apprehension by the court of the legal result, either of the construction of the documents or the weight of certain circumstances. If this was permitted, litigation would have no end, except when legal ingenuity is exhausted. The next, at page 21, using the internal numbering, at the top of the page, is a summary of the law of issue estoppel, namely that, where it said it can be seen from the citation of authority that if in any court of competent jurisdiction...
Sorry, I've got...
Page 25.
25.
Sorry, my mistake. Top of the page there, seen from the citation of authority that if in any court of competent a decision is reached, the parties have stopped from the questioning in a new legal act proceedings, but the principle also extends to any point whether assumption or admission, which was in substance a ratio or fundamental to that decision. Now, although this refers to assumptions or admissions, it plainly also extends to determinations by the court in the first judgment. And the important point here is that it directs the court's attention to what was in substance fundamental to the first decision. This issue estoppel is not a doctrine concerned with a narrow question of the result of the first hearing, but its focus is on what was actually mattered in the court in the first round of litigation. So it's focusing on what actually mattered to the court in the first round of litigation. So to take a very simple example, person X may claim against person Y for personal injury arising out of a road traffic act. Let's say that the court concludes that person Y is not liable. In that case, the issue of estoppel is not limited to the ultimate result. The finding that Y is not liable, issue of estoppel would extend to all the essential steps that led to that conclusion. Now, that would obviously depend on the precise facts, but issue of estoppel could include findings of duty of care, breach, and so, for example, if the judge had concluded the person Y was not liable because they were not driving the other car, this would give rise to an issue of estoppel. In other words, in the words of Lord Shaw, issue of estoppel applies to whatever conclusions are fundamental to the decision that the judge actually made. And that the court is concerned with the essential steps in the reasoning rather than the end result can be seen from this decision going forward to page 26. And here Lord Shaw was dealing with an argument that the admission that the taxpayers were joint owners in the first claim was only incidental or collaterally related to the point that was being litigated. And as you can see from the passage starting halfway down, much stress, it was suggested that there'd been no express decision on joint ownership in the first case. And what he says is much stress was laid on the fact that in the present case, an express decision upon the point of joint ownership was come to, and that this was not so in the former case, to which the answer is contained in a reference to the language in the statute, namely that where under settlement income is shared by the relatives of the settlor in such a way that they are taxable as joint owners under this act, then for the purpose of the joint assessment as such joint owners, they may be deducted in respect of each joint owners who held an original share in land £5,000. The former judgment was pronounced by the Australian courts under that section It was not merely incidental or collateral to the decision so decided that the appellants were joint owners. It was fundamental to it. Unless it had been decided that under the settlement Mr. Campbell's children had a beneficiary interest in land or in income in such a way that they were joint owners, they could not have been taxed at all. On this portion of the case, the Lordships entirely accord with the judgment of Justice Higgins in the full court. So the issue of estoppel arose as to joint ownership, despite the lack of express words in the first judgment that the taxpayers were joint owners. It was inherent in the judgment, and one must therefore read the first judgment and the applicable legal rules to see what the essential steps were in any decision.
To be fair, that's very different from our case, isn't it?
Sorry, very.
That has no analogy in our case.
No, that's correct. It's not a question by inference or anything like that. Well, in our case, when one looks at what was decided by Justice Andrew Baker,
it's sort of almost, the question is almost sort of the reverse. The question is where a judge has arrived at a conclusion which on one view is wider than he needed to come to decide an issue. Is that binding? I mean, can I give a silly example? Suppose you have a contractual dispute and the judge says, claimant loses, first because for a contract there is no requirement for consideration, second because even if there is a requirement for consideration, as a matter of construction it doesn't apply. Now, plainly there is a requirement for consideration for a contract. When the same parties are years on engaged in a dispute relating to a different contract, is the determination previously that there is no requirement for consideration binding?
It's a different contract.
But the issue was...
Yeah, I can see that. Yeah, I mean, we'll come to this when we come to look at the particular facts, and that sort of nuance doesn't arise because it is absolutely clear, we submit, how Mr. Justice Andrew Baker dealt with this case. And what is clear is that he's looking at it as a question of substance, and the question of private causes of action form no part of the analysis. So it's not an answer to say, well, he was only dealing with a claim on the vouchers in relation to negligent misstatement. He was not dealing with deceit, and therefore it's not binding. When one comes to look at all those passages that we've looked at, the judge was looking at it in a very different way.
Yeah.
I mean, well, I was about to go on to another case, Blair and Curran, which is going to take a bit of time.
Take a few minutes. In that case, let's break now and start again at 2 o'clock. I assume we're still all right for time.
We are, yes.
Yeah, good. 2 o'clock then.